applicant with us today?
Yes, she is, Judge. She just has to turn on her camera.
Okay, thank you. Okay, we now see her. All right. Attorney Perry, as you represent the appellant, did you wish to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes. May it please the court.
Okay. I will make that notation, and with that, we are ready to begin.
May it please the court. My name is Allison Perry, and I represent the appellant, the former husband, Sean Matheson, in this appeal. This case involves a time-sharing issue. The parenting plan that was recommended by the guardian ad litem recommended that the father have more liberal visitation or time-sharing than the court awarded, and also the former wife requested that there be more time-sharing than the court awarded. The former husband states this is an abuse of discretion. Since
let me ask you a question here. I thought that the wife proposed 130 overnights a year, and the trial court gave your client 140.
Those are not the calculations that I came up with. I came up with that there were 33 days, extra days, but I believe I was off by 1 week. But there were like 29 additional days that the guardian ad litem would have awarded. And this doesn't include the Thursday overnight, the Thursday time sharing with the alternating the children. As you know, Florida recommends that there be liberal time sharing in between parents that are divorced. And here we just ask that the court award time sharing that the parties themselves agreed to. I mean, not agreed to, but the former wife promoted. The other issue on appeal is the cumulative effect of the alimony and child support award leaves the husband with the inability to pay his basic living expenses. I think this case law is clear on this issue.
Let me ask you another question about that. His July 2021 financial affidavit listed living expenses at $3672.
Correct.
And that was unrebutted, right? His most recent, the financial affidavit was most recent, which was, I think, July of 2022, shows that his net monthly income had increased by more than $600, right?
Correct.
And that increase pretty much corresponds directly to the deficit that he's now complaining about, right?
No, Your Honor, if you look at on page 3086 of the record, that is the page that the court states that the husband's net income was $4,118.73. And his expenses on the affidavit were $3,672.54. But these expenses do not take into account his child support obligation of over $600. When you take into account the child support obligation, the husband does not have enough money to cover his basic expenses, which is exactly what this court has found to be an abuse of discretion. The case that I cite from this court is Gerard v. Gerard. And in that case, this court held that leaving a alimony obligator with only $2,000 per month to pay his own living expenses after making his alimony payment, child support payment, student loan payment, and other payments. It said he could not.
Help me out here. Does he not end up with $3,000 a month for his monthly expenses when that is deducted from his net monthly income of $4,118?
Correct. And $3,000 a month is not enough to meet the $3,674 worth of expenses, which is why he doesn't have the ability to pay alimony. The court just didn't consider the cumulative effect of requiring this man to pay durational alimony when he had a child support obligation that hadn't been taken into account. So that's where the abuse of discretion lies. And I mean, this is a very, simple case of math, and you just can't make money appear from where money doesn't exist. And he just does not have the capacity. You're setting up a family to be going to contempt hearings because he's not going to have the ability to pay this durational alimony. And, under Bowman, it's going to be assumed that he has the ability to pay the alimony. So, to avoid future contempt hearings, this court needs to reverse this.
I'm sorry to get tricked up in the math, but that really is the linchpin of what you've got going on here. Wasn't his net income as of July 2022 $4,724?
His net income, that's not the income that was utilized. If you look on 3,086 of the final judgment, the net income that was utilized was $4,118.73.
I understand, but help me out. His affidavit from July 2022 is in the record, and it shows that his net monthly income is $4,724, right?
I don't have that in front of me, Your Honor. I'm assuming that you are telling me accurate, so I would say yes. I can get it while I'm on break. But the figures that are used in the final judgment, and since there is no transcript of the final hearing, we have to use what was in the final judgment. And in the final judgment, the math is clear that he does not have the ability to pay this durational alimony. And those are the figures that were used. Again, I request that this court reverse and award the husband at least the time sharing that the guardian ad litem recommended, if not that of the wife, or the husband's 50-50. Also, I ask that you reverse the durational alimony award, since under the final judgment, which is what we're going by, the husband does not have the ability to pay this $600 a month durational alimony. Thank you, Your Honors.
Thank you. Ms. Mathena, the ability to address the legal issues on appeal now is your chance to address. You have 20 minutes. You can use all or none of it. It's up to you.
May it please the court, my name is Tabitha Mathena. I'm the pro se appellee, and here to respond to the initial brief that was submitted by the opposing counsel on the issues of time sharing and the alimony calculations. The time sharing was definitely a bulk of the matter discussed during court. The final hearing, mind you, sorry. Pardon my nerves. And while it didn't exactly line up with the guardian ad litem suggested, the calculations that were shown in the initial brief are erroneous in that it resulted in about 21 days difference, 1 day every other week, once you factor out the holidays that we all, even out, if that makes sense. And they did still get the third week over the summer. So it was a small variance from what the GAL did suggest, but there was large amounts of testimony that focused on the husband's or the ex-husband's inability to provide a stable routine and household, mentioning the fact that he's now had 4 residences since we separated, or 4 jobs, 3 households. And it was more beneficial for the children to remain in my primary care and with his time sharing as it is laid out. And I should mention that while laying out this final judgment's time sharing, he had to ask me to modify it because he couldn't handle the midweek visit. And he attached it to his weekend. So he just has a 4-day weekend every other weekend because it was too hard on him and the kids to do that Wednesday, middle of the week. So it doesn't make sense to go back to it if it wasn't working out in effect. And in the matter of the alimony, I do believe that I showed the calculations fairly clearly in my answer brief. I don't know how to tell you where to look, but it would be on page 9, I guess, of my response, my answer brief, where I explained the math that was used. Part of the final hearing, there was the judge reserved, sorry, I'm stumbling. The judge reserved, I think it's called jurisdiction, solely on his income, not on reconsidering new expenses or anything like that. And likewise, I was not able to submit new data as far as my expenses or income or anything like that. It was solely to take new information on his income, which at the time of this, his most recent financial, or I'm sorry, at the time of the final hearing, his most recent financial affidavit did say that number that you had quoted, which was the $4,724. And from that, once you subtract out the alimony and the child support that was calculated, it equalized the households to within $10 net per month, which it works, the math works. I don't know the official way to support that with cases or whatnot, I'm sorry, but are there any questions that I should try to clarify maybe?
I'm not seeing it on my screen. So I assume you are explaining it well enough for us to understand.
Okay, sorry.
No, don't worry.
So I think that addressed the calculations as well as the judge's decision for his choice with the time sharing schedule. It was not an abuse of discretion, and there is no error apparent on the face of his judgment. So I would ask that you uphold the final judgment and leave things as they are. The end.
You need to then answer my question. Is that the conclusion of your remarks?
Yes.
Okay.
Sorry.
Thank you very much. No, I just don't want to cut you off. And I know you don't make your living doing this. I want to make sure if you wanted all 20 minutes, you got your chance to use them all. Okay. All right. Attorney Perry, you still have your 5 minutes.
Yes, Your Honor. Thank you. I just want to remind the court that there's case law that says equalizing household income is not the purpose of alimony award. That is not in my brief, but I can supply supplemental authority if you would like that. On the face of the judgment, again on page 3086, it is using the August 11th, 2022 financial affidavit regarding the new employment. And that net income is $41,118.73. And the expenses are taken off of his July 9th, 2021 financial affidavit. And those expenses were undisputed at $36,000. And I don't think the former wife is trying to dispute any of his expenses.
How do we know what was disputed or what wasn't without a transcript of the hearing, Ms. Perry?
Because it says the husband's July 9th, 2021 financial affidavit lists his monthly expenses at $3,672, and there was no evidence to rebut the reasonableness of these expenses.
That doesn't mean it was undisputed. It just means that the judge made a finding.
Well, right, but that's the finding that you're stuck with because the court found that these were reasonable expenses.
Okay.
Okay, so I ask that the court adopt the guardian ad litem or the husband's 50-50 time sharing schedule. and also reverse the durational alimony award, as he does not have the ability to pay under the facts of this case. Thank you, Your Honor.
Thank you. Thank you both. Yes, you can both exit electronically. This proceeding is concluded, and we will in the future get back to everybody. You'll see us in writing. That's how we do it. Thank you all.
Thank you, Your Honor.
That closes this session, and I guess for those of us who are technologically challenged like me, we hit the leave button.